OC World is made possible by the generous contributions of the Marisla Foundation, the Keith and Judy Swain Family Foundation, and viewers like you. Thank you. Welcome to OC World. I'm your host, Joone Kim-Lopez. And today we have a guest who is a visionary with a legal mind that rivals the encyclopedia. For those of us who still get that correlation. And in 2017, National Jurist magazine named him the most influential person in legal education, earning him the reputation as a world-renowned rock star scholar. He is Erwin Chemerinsky, and whether you are of the left or right lean in your political views, there's no denying that he forecasted years ago the recent Supreme Court rulings that have jolted America. In our special two-part series, we will examine how these events transpired and what it means going forward. As the founding dean of UC Irvine School of Law and now serving as the dean of UC Berkeley Law, Erwin Chemerinsky has taught and inspired generations through his brilliance and passion for reason. His book, We the People, serves as a modern-day must-read in understanding the conflict and challenges in the application of the U.S. Constitution and the political dynamics that drive our current legal system. His perspectives and vision give us a pathway to understanding how and why we got here as a country, and how we might be hopeful about the future in these unprecedented and volatile times. Thank you for joining us, Erwin.
Thank you so much for having me.
It's so great to have you here at OC World at UC Irvine, where you just finished the 12th annual Supreme Court review, which was fascinating. And we're going to get into all of that. But for our viewers who may not be as familiar with you, just want to get a little sense of who you are. So maybe start with telling us how and when you got into the field of law.
I grew up in Chicago in a working class family. I'm the first in my family to ever go to college. And if you were to talk to me at any point in college, I would have said I wanted to be a high school teacher. And I took all the classes and got certified as a high school social studies teacher, but then decided to go to law school. And the reason is I believed then and believe now that law is the most powerful tool for social change. I wanted to be part of that.
Well, and you're not a typical scholar because you don't just study, but as you talked about, your initial passion was to teach, and that's what you do, but you've also done pro bono work and you've appeared before the Supreme Court. So you don't just study, you actually are in the trenches of advocating for justice. And there's one of the quotes that I understand is your favorite, which is justice, justice, thou shalt pursue. And you talk about how Constitution affects everyone. So maybe give us a little sense of why that quote is so important to you and your approach.
In fact, if you come to my office, you'll see a beautiful poster that has it in both Hebrew and English. If you come to my study at home, you'll see on 2 different walls I have that quote. I think it's so important. And it's interesting, why does it say, justice, justice thou shalt pursue? And I think the explanation is it's a reminder that we both have to have fairness in the way we treat people, and we have to have just outcomes. Both are essential in any society.
So before we get into some of these recent Supreme Court rulings, and we have a lot to cover, as you talked about, this was definitely unprecedented in terms of the amount and the types of ruling that we've seen. But just to set a base of understanding for our viewers, in your book, We the People, you lay out a very easy to understand foundation of how the U.S. Constitution gets interpreted. I mean, it was adopted in 1791, which was a long, long, long time ago. A lot has changed. So maybe talk a little bit about what you see, and you describe it as originalism, and then we'll get into some of the Supreme Court structure.
The phrase "we the people," of course, comes from the preamble of the Constitution. And I think the preamble sets out some of the basic values that the Constitution is meant to achieve. Democratic governance, effective governance, protecting liberty, justice. Now, there's one value that isn't mentioned in the preamble, and that's equality. Not surprising, it's not in the preamble. The Constitution institutionalized slavery. Women had no rights under the Constitution. But equality, equal protection, was added to the Constitution in 1868 as part of the 14th Amendment. And I think what's important is we should interpret the Constitution to achieve those goals. I don't think we have to follow the specific views of those in 1787 or 1791 or 1868. They lived in a very different world. But I think what we should always try to do is achieve those underlying objectives.
Well, that makes perfect common sense. Are there people who would disagree with that?
Yes, and unfortunately, a majority of the Supreme Court would. They are, as you referred to, self-described originalists. They believe that the meaning of a constitutional provision is fixed when it's adopted. So the First Amendment about freedom of speech means the same thing today was adopted in 1791. Or the 14th Amendment that I alluded to means the same thing today was adopted in 1868. I think it's absurd because those who lived then couldn't have envisioned our modern problems. Let me give an example from this term of the court. There was an issue about whether a high school football coach could go onto the 50-yard line and engage in prayer. Ask the question, in 1791, when the First Amendment was adopted, did the framers of the Constitution think about high school football coaches at public schools engaging in prayer? Of course not. There wasn't football and there weren't public schools. So that's why it doesn't make sense to say we're going to be governed by what they thought long ago.
Well, and you even mentioned as an example, there is no pronoun she in the Constitution. So then what would someone who disagrees with you and says, well, we have to read by its original text, how do they justify that? How do they respond to your view on how the Constitution should be a living document, as you call it?
The strongest argument for originalism is, at least according to its proponents, it's a way of constraining the judges. If the judges have to follow what was the original meaning, we limit their ability to impose their own values. But I think, I know it's a strong word, that's nonsense. It doesn't constrain the judges. In part because history is ambiguous, that there were conflicting practices at the time. Some of it also is that the world has changed so much, you can't ask today, what would they have thought about circumstances they could have never envisioned? And also the reality is the conservative justices abandon originalism when it doesn't get to the goals they want. I'll give a specific example. There's an issue that's going to come before the Supreme Court in October, is whether college universities can engage in affirmative action. The same Congress that ratified the 14th Amendment in 1868 adopted many programs that were race conscious that we would call affirmative action today. So if we really wanted to be originalists, affirmative action is constitutional. But the conservative justices never mention that history. They use originalism when it gets to where they want to go, but ignore it otherwise.
Which implies that you say value neutrality is unreal because everyone has ideology, even our Supreme Court justice. And we like to think that the highest court of the land and these justices would not look at it from their own lens, but that's not what you describe we're seeing today. So how do we put checks and balances to that?
I think what you say is so important. The words of the Constitution are ambiguous. How those words are interpreted is very much a function of who's on the court at any point in time. From the 1890s to 1936, there was a very conservative court, and it struck down over 200 progressive laws protecting workers and consumers. In the 1960s, we had a very liberal court, the Warren Court, and that was reflecting its ideology. There's a New York Times story on Saturday, July 2nd, that said that this was the most conservative term of the court since 1931. Well, why was it? Because we have the most conservative set of justices that we've had since then. Why did the Republicans block Merrick Garland? Why did the Republicans rush through Amy Coney Barrett? Because everyone knows that the identity of the justice is crucial in terms of the results from the court.
Now, you mentioned the word progressive, and everyone has a slight different definition of words these days. So you have conservative, you have progressive, you have liberals. How do you define those three words?
I think what's key is to use the common application in our society. Think about the issues that divide those who are conservative and those who are liberal. Abortion rights. Generally, conservatives are against abortion rights. Liberals favor abortion rights. Gun rights. Conservatives generally favor gun rights. Liberals favor gun control. Separation of church and state. Conservatives don't believe there should be a separation of church and state. Liberals believe in a wall that separates church and state. We could go on with so many issues like that. And what's interesting is the Supreme Court exactly parallels society. The conservative justices taking the conservative political position, the liberal justices taking the liberal position. And I'm using liberal and progressive interchangeably.
Okay, that's good to know, because you talk about the progressive vision. So let's get right into some of these rulings. Dobbs, which basically overturned Roe versus Wade, which has been in the books for over 50 years. And it's an interesting decision on many different levels. But let's just start with the two views. Clearly, those who are of the progressive, it's an outrage. Those who are conservative are elated. And some will say, well, what's the big deal? Because it gives the states the ability to make this decision. So it's not a complete overturning of Roe versus Wade. You could still keep those elements, but you leave the power to the state. How do you respond to that view?
It is a complete overturning of Roe versus Wade. Roe versus Wade said that until the fetus is viable, it's left to each woman to decide for herself whether to have an abortion or continue the pregnancy. The Supreme Court overruled that and said each state gets to decide. Over half the states have laws that will prohibit all or virtually all abortions. Women in those states who have an unwanted pregnancy now have a choice. They can travel to a state where abortion is legal, but only if they have the resources to do that. They don't. Poor women, disproportionately women of color, teenagers. Then they have to decide between an unwanted child and an unsafe back alley abortion. It's for these women in their lives that overruling Roe versus Wade is going to make such a difference.
In your recent article, you said states like Missouri are actually contemplating banning women from traveling outside of the state to get abortion. So does that mean women who want to get abortion are essentially trapped? I mean, what is a ramification of those kinds of policies and laws?
A bill has been introduced into the Missouri legislature, and I expect it will be introduced to other conservative state legislatures too, to make it a crime for a woman to go out of state for an abortion. Now, I don't think those laws are constitutional. I think they violate the right to travel. But to see after those are litigated. But it's dramatic in terms of how much states that are anti-abortion want to go in restricting choices for women.
Now, for those who have for years argued against Roe versus Wade, they have not been successful, but this term that they were. But what's interesting to me is that many of the conservative justices on the Supreme Court, as part of their confirmation, said that they would support Roe versus Wade, and this notion of respecting precedented rulings. What happened to that?
They lied. They said what was necessary at the time to get confirmed. They knew that once they were on the court, they could do whatever they want. So I remember when Susan Collins, the senator from Maine, cast the decisive vote for the confirmation of Brett Kavanaugh. She said, he assured me that he would follow precedent, not overrule Roe versus Wade. I was surprised she believed him. And then, of course, after he voted to overrule Roe versus Wade on June 24th, she said, he lied to me. Why was she shocked by that? Everyone knew that he and the other conservative justices were saying what they needed to at the moment to get confirmed.
Then where's the consequences of that? I mean, if any public official, or even you and I, if we were to lie, there's an impact. So when a justice, as your words, lies, what happens? There's no consequences?
There's no consequences. In theory, if a majority of the House voted to remove the person and 2/3 of the Senate agreed, then there could be a consequence, but that's not going to happen. And so in the real world, there's no consequence. And these individuals knew when they lied that there would be no consequence. They could say whatever they wanted at the confirmation hearing, and if they got the votes, they could do whatever they wanted once they became justices.
I think That surprises a lot of people, particularly because these terms on the Supreme Court is a lifetime. So you're there until you retire or you die. And many of the justices, if not all, have stepped down at a very late in their lives. Is there no other remedy to provide a greater check and balance, whether it's this term of Supreme Court justices or in the future? Do they have absolute power?
They don't have absolute power, but the remedies are very difficult to use. The Constitution can be amended to overturn a Supreme Court decision interpreting the Constitution. That's happened 4 times in American history. But remember, to amend the Constitution takes 2/3 approval of both houses of Congress and then approval of 3/4 of the states. We're not going to do that to create a right to abortion or overturn any of the recent Supreme Court decisions. A Supreme Court justice could be impeached and removed. It takes a majority of the House and 2/3 of the Senate. That's not going to happen. The check really is in the long term. It's who we elect as president and who fills vacancies on the Supreme Court. Had Hillary Clinton won in 2016 rather than Donald Trump, and had she picked 3 justices, Roe versus Wade wouldn't have been overruled. None of the cases this term would have come out that way. So ultimately, the check in the long term is the political process in elections.
Do you ever get criticized for talking about the progressive vision and talking for more of the liberal perspective and not enough about the conservative view? Because you just mentioned Hillary Clinton. There are some people who absolutely were supporters. There were absolutely people who are supporters. I mean, it's very polarizing right now in our nation when it comes to Republicans and Democrats. So have you ever been accused of that as a scholar?
I get criticized all the time. Would you like to see the hate email I get, including from this morning? On the other hand, I think that no one can deny that had Hillary Clinton picked 3 justices, it would be a different court and the results would be different. That's the nature of the court. It's so much a function of who's there.
Well, the next ruling I want to talk about, which is interesting to me, given our, the conversation we just had about Roe versus Wade, which is the gun control issue from New York. And there, the Supreme Court has ruled that the states don't get to decide because states like California have much more restrictive gun laws than other parts of the country. This is where the court has said it's the federal, across the board, loosening up gun control, yet when it came to Dobbs, it was the other way around. So maybe you can talk a little bit about the gun control ruling and how do you reconcile that perspective?
The case was New York Rifle and Pistol Association versus Bruin. It involves a New York law that was adopted in 1911. And it said in order to have a weapon in public, a concealed weapon, a person needs a permit. In order to get a permit, a person would need to show a cause for having one. And that means the person has to show a safety need for a concealed weapon. California has almost identical law. The Supreme Court, in a 6-3 decision, declared this unconstitutional. Justice Clarence Thomas said that the Second Amendment protects the people to have weapons in public, and that includes concealed weapons. That laws that restrict concealed weapons in this way are unconstitutional. One key thing to remember is that from 1791, when the Second Amendment was adopted, till June 2008, not one federal, state, or local gun law was struck down by the Supreme Court. During all this time, the Supreme Court said the Second Amendment is just about a right to have guns for militia service. And now the Supreme Court has very broadly protected the right to have guns, including concealed guns in public.
What does that mean? What's across the country? Is everything changing? How do you step through as a layperson to understand these major decisions? And the question is, so what happens next week?
There are 6 states, New York and California being 2 of them, that have laws that say in order to have a concealed weapon in public, you need a permit and you need to show cause. Those laws are unconstitutional. Now, Justice Thomas went further than that, and he said, the only regulation of guns that's allowed is that which has been historically permitted. In other words, the kind of regulation allowed in 1791 or in 1868. And so any kind of law that restricts guns is now open to challenge. And what the government is going to have to show is that it's a kind of regulation that existed. in 1791 or 1868. The court has really opened the door to challenge to virtually all firearm regulation. And I want to go back to where you started here. In Dobbs, the Supreme Court said, let's leave abortion to the political process. Here the court saying, when it comes to gun regulation, we're not going to leave it to the political process.
So when do they call it states and when do they call it federal?
Well, I think the question is, when do they leave it to the political process, and when do they say the Constitution limits the political process? For abortion, they said, it's left to the political process. For now, it's left to the states. But Congress could pass a law giving right to abortion all over the country or prohibiting abortions all over the country. When it comes to the Second Amendment, they're saying states and the federal government don't get to make the choice. The only thing they can do is that which is historically permitted.
For a lay person, again, that sounds a little arbitrary and a little hard to follow. How can we better understand when and how these lenses are applied, or is there? Is it as subjective as it's sounding like?
I think it is as subjective as it's sounding like. It's about the values of the justices. They strongly favor gun rights. They strongly oppose abortion rights, just as conservatives and Republicans generally do in our society. And that's what constitutional law now reflects.
Okay, so we've done a little bit of analysis. We've done a little bit of perspective. Let's do a little projection, because you've been very good at this. So much of what you have talked about, and in your book, We the People, which was published in 2018, that was 4 years ago. And you saw these rulings coming. And you also talked about, in many of your commentaries and articles, about how this is not the end of the overturning of Roe versus Wade or the loosening of gun control. So going back a little bit back to Roe versus Wade, you said this is going to have other ramifications such as same-sex marriage and contraception. Can you talk a little bit about where you think this might further go?
I want to go back to Dobbs that we were talking about earlier. Justice Alito wrote for the court, and he said, a right can be protected under the Constitution only if it is either in the text of the document, or as part of its original understanding, or as a long, unbroken history and tradition of protecting it. Well, think about the right to purchase and use contraceptives. The Supreme Court didn't first protect that until 1965 in Griswold versus Connecticut. It's not in the text. It wasn't part of the original understanding of the Constitution. There's not a long, unbroken tradition. I expect some states are going to now outlaw the morning after pill or even IUDs because they take effect after conception. Talk about the right of consenting adults to engage in private same-sex sexual activity. It wasn't until 2003 in Lawrence versus Texas that the Supreme Court said that the right to privacy protects the right of consenting adults to engage in sex whoever they want in their bedroom. There's no long, unbroken tradition. It wasn't part of the history. It wasn't part of the text. Or take the right to same-sex marriage. It wasn't until 2015, in Obergefell versus Hodges, that the Supreme Court says that gays and lesbians have the right to marry. Same thing, not part of the text, not part of the original meaning, no history of protection. And in fact, Justice Clarence Thomas wrote a concurring opinion in Dobbs saying we should overrule Griswold, Lawrence, Obergefell, the rights to contraception, the right to engage in consensual sex, the right to same-sex marriage.
Well, and it's interesting because we think that we've come such a long way in some aspects. And whether you're the left or the right, it seems like the hands of times are turning a bit backwards, if not a lot. And it also seems a little bit out of touch for many because there's been so many stories, tragedies in the news with mass shootings. And just recently with the 4th of July parade. Given all that, the loosening of gun control, help the public understand, help us understand how in the face of what's happening right now at the level that we're seeing, that we could have loosening of the gun control.
Justice Breyer began his dissent in the Second Amendment case by talking about the number of gun deaths in the United States. He talked about the prevalence of mass shootings. He mentioned what went on in Buffalo, New York earlier this year, went on Uvalde, Texas earlier this year. And of course, as you say, even since then, there was the tragedy in Highland Park, Illinois on the 4th of July. And he says, this shows why we need to give the government the power to regulate guns. He compares states that have laws restricting concealed weapons and those that don't. It shows that the laws with the regulations have far fewer gun deaths. I think the Supreme Court, in Justice Thomas' opinion, simply doesn't care about that. In fact, Justice Alito wrote a separate opinion in the case saying none of that matters. For them, the Second Amendment should be taken what it meant in 1791, a broad right for people to have guns.
Well, in our part 2, we're going to get into some of these other rulings and some of your other projections and what's ahead for the Supreme Court. Because right now, they're on a break until October when they resume. When you look at some of these other issues that we're going to get into, separation of church and the state, freedom of speech, climate change, all these things that we're seeing, how would you encourage or advise the general public to track and to really stay current with what's going on? Because an informed group of individuals are much better prepared to weigh in. But seems like a lot of these things happen we only hear about it once the decision has been made. How can we better track this going forward?
You're absolutely right. What's key is for people to be informed and for people to be involved. Thankfully, because of the internet, it's easy for people to get informed. There is a website called SCOTUS blog that previews all of the cases that are on the docket, that reports about them when there's oral arguments, and then covers them with decisions. And of course, all the major newspapers cover the decisions that we've been talking about. And then I think what's key is people to get engaged and involved.
Well, we really appreciate that and can't wait for the part 2. We thank you so much for joining us today, and we look forward to seeing you again. You can't miss the part 2. We're just getting started. We're talking about so many different issues that impact all of us, regardless of our views, throughout the country, through multiple generations. In our part 2, we're going to get more into these issues and more into Erwin's projections. And we'd like to also hear from you, your thoughts. So send us your comments, what you think of our interview, and how we can, as OC World, help you stay better informed. Thank you. Until next time, stay safe and be well.